So we are going to have the next session, the interesting session on a very relevant subject for the organizations, sexual harassment of women at workplaces, the Act 2013. This is very important act, and we have here an expert on the subject, Mr. G.M. Sani. I request him to kindly, Sani sir, come and take your seat, sir. Sani sir is a labor law expert and doing a lot of advisory services associated with many organizations, and he will give you insight of the provisions of the Act. Now, I request Priyanka Goswami, advocate, I mean to kindly please come. She is an advocate in the Supreme Court and an expert on the subject. Now I request Executive Director Atanu Bhomik, Executive Director Law and HR, Engineers India Limited, to kindly come on. And now I request Dr. S.P. Mitra to please come on the dais. It is customary for us to honor our respected guest. So we request Mr. Francis Mitra to honor G.M. Sani sir. Next, I request Sri Sanjeev Agarwal, General Manager Legal from influx, to kindly honor Bhomik Sahab, Executive Director Engineer. And now I request Dr. S.P. Mitra to honor Mr. Priyanka Goswami. Now we are going to start the program, and I request Mr. G.M. Sani, Advocate Labor and Employment Law, to kindly take over and address our audience.
Thank you. In order to make this program and this, presentation effective, what we have proposed that Mr. Sani is a very senior veteran from our profession. In fact, he used to be my professor in LLM also. So, with a very, very, knowledgeable person, he will make a presentation for about 30-35 minutes, right? Post presentation, Madam Priyanka would speak on the, because she is a very, seasoned advocate practicing in the Delhi High Court, and she is, in fact, promoting the cause of the, women. So she deals with the subject that wherever the modesty of the, women is outraged, people generally come over to her to seek redressal. So she is here. She will definitely bring about 2-3, the live examples before you, how she has dealt with such subjects. Followed by Mr. Atanu Bhumik will be here, being ED law and HR. He will give you the complete, understanding how the implementation of this statute being complied with appropriately in a PSU-like setup. So, and post that, the panel will be made available for interactive, discussions. So, whatever the issues you have in mind, please hold them back till the presentation is over and the address by Madam Priyanka and Mr. Atanu. Post their the speech, please come up with your issues. I'm sure there will be much takeaway. So have some patience to ask the questions till the presentation and the speeches are over. Thank you so much.
Everyone, very sensitive subject. Really matter of shame also that such a legislation act.
रखा और नजदीक कर दो।
और भी ज़्यादा बड़ा नहीं है, आप थोड़ा लाउडली बोलो तो ऐसे सुनाई देगा।
मित्र साहब ने कहा है लाउडली बोलो, लेकिन टाइम बहुत कम दिया है। इसमें सीज करना बड़ा मुश्किल हो जाता है, पूरा दिन लग जाता है प्रोग्राम को करने में। I try to remain within the time and I try to confine to limited salient features only. Everybody knows what is this act about. I'll discuss few points only. I'll keep on jumping. Yes. These are the main definitions in the agreed woman. This is the, I don't want to say the heroine of this film, but victim of this episode. Who is agreed woman? Act is categorized in two ways, at workplace and at domestic place. The difference is, at workplace, the women may be employed or not employed. This is the main difference. And at workplace, at domestic place, the women should be employed. Because at workplace, it can be any woman who is visiting the establishment. Something wrong can happen with that. So that will be covered. At domestic, the relatives, they are not covered. But if you have a maid or any employee, women employee, that will be covered. Respondent is again not the hero but the villain of this. Domestic worker, you understand the employee, particularly women employees, we employ at home. Employee, any employee, again coming to that, working, whatever category, whether temporary, permanent, professional, in any classification, who is working in any establishment, he is an employee, whether it is fully contracted scheme or it is engaged directly. Employer in government or establishment, the employer is different. That means senior officers, secretaries, etc. And private sector, which we are more concerned, are the senior bosses. They are the employers. Workplace. This is important. Workplace is not confined to the premises of the establishment. There is a notional extension of workplace. You people have come from your establishment to attend this training program. If something unfortunately happens here with somebody, this is the extended workplace. You are traveling in company's transport. You are attending any program outstation, even abroad, related to work. Something happens there, that is workplace. Even during COVID period, as they had work from home, something happens there, that is workplace. So workplace is a very wide term, not confined to the building of the establishment. What is sexual harassment? That is important, but we are going to discuss. Any physical contact and advances. I think I need not go in more details because of the time constraint. Any demand or request for sexual favor by the respondent from the agreed movement. Making sexually colored remarks, showing pornography, any other unwelcome physical, verbal, non-verbal conduct of sexual nature. That is sexual harassment. Implied or explicit promise of preferential treatment in an employment. Okay, you give me this favor, I'll promote you. I'll give you increment. I'll give you better assignment. So that will also fall in sexual harassment. Threat of detrimental treatment. If you don't agree with me, if you don't go with me for a coffee outside, I can remove you. I can transfer to your wrong place. I can do any other wrong thing. Threat about her present or future employment status. If the government doesn't take it. Interference with the work, creating an intimidating, offensive, hostile work environment for her. I'm sorry, this had to be elaborated if we had a full day program. Humiliating treatment likely to affect her health or safety. This is silent killer for any human who is suffering from this. Quid pro quo, this is also something for something. You give me what I require from you sexually, and I in return give you this much benefit establishment. Creating hostile work environment for the agreed woman so that she submits to the sexual demands and advances of the we have to make internal committee. There is a provision under section. There has to be one senior woman who will be the presiding officer. There will be 2 members from the having some knowledge about this subject, and 1 member from outside and chief. Not less than half member should be the women. Practically, it may be suggested instead of 4, you may have 5 so that you can have balance. Then there is a division in opinion. Local committee is not at workplace. It is outside the workplace, where there is no establishment. Where the district administration they make committee just on the civil lines. The chairman is the prominent women of the society, and there are members from the area which are working for the welfare of the women. Right? 2 members were nominated from the NGO, etc. So this is a separate parallel arrangement in the non-establishment status. Plus, where the complaint is against the employer of the establishment, then that complaint will go to this government will notify the district officer who will respond. Light bill. Okay. The internal committee that will conduct the inquiry in the cases of sexual harassment. What is the procedure for conducting the inquiry? The agreed movement has to submit complaint in 6 copies. One copy to be retained by each member, and one copy is sent to the perpetrator, to the respondent, which is 7 days, and he has to reply back his defense within 10 days with the document, the name of his witnesses, or whatever he has to say. But there is also a provision of conciliation. If the movement does not want to face the inquiry committee for whatever reason, there can be a conciliation proceeding, but there should be no monetary consideration for that. Okay, I'll compromise if you give me so much benefit. So that should not be the criteria for conciliation. In that case, there is no need for conducting the inquiry. But when the conciliation agreement, the settlement, is not honored by the respondent, the matter goes back to inquiry committee, and it will be inquired into. Inquiry committee has a lot of powers. They, like civil courts, they can summon the person to appear, they can ask for document, they can do anything else what they feel is necessary. Committee also has a power, if there is no service rule, to recommend after the person is held guilty, what punishment should be awarded to that person. It could be censure, it could be warning, it could be stoppage of increment, it could be demotion, it could even go to termination. So there is also provision for doing community service, which in our country is not very popular. The woman has to make a complaint. The complaint has to be in writing, no purpose. Right? Employer, the management will assist the woman if she has difficulty in making the complaint in writing. Conciliation I have discussed, inquiry. When the respondent has been proved guilty, the committee can pass an order for making the compensation to the lady. What is the compensation? For the mental loss, for the treatment she has suffered, psychological treatment, for any other thing she has suffered. For that, a compensation amount is to be allowed to this lady, which has to be paid by the respondent. If he is working, it has to be deducted from the salary. If he is not working, it can be collected to the collector as area of land revenue. Inquiry has to be completed in 90 days. These are the powers to the committee. To someone to enforce attendance of any person to examine the form. if the respondent or the women doesn't appear in the inquiry committee, they miss the meeting 3 times, and after giving a 15 days notice, the committee can pass an accordingly. Legal practitioners are not allowed in this meeting. Quorum is 3 persons of the committee members. This is always very rare. Every inquiry has to be conducted as per principles of justice. On written request of agreed women, LC may transfer, agreement transfer of agreed women to other place so that they don't work together, or transfer of the man to other place so that they are not together. This is another provision. The women can ask for leave, especially for the 3 months, that is in addition to the normal statutory leave applicable. Any other leave, employer has to send compliance to committee and to the local committee where applicable. Restrain respondent from reporting work performance and supervision. Inquiry which I discussed. Within 10 days of completion of the inquiry committee has to submit a report. Order has to be speaking order with reason, conclusion, supported by evidence and report. If allegations are not true, no action is implemented. If allegations are true, then action can be implemented. It has to be treated as misconduct as per the service rules. This I mentioned the compensation. While this compensation is paid for loss in career opportunity, for medical expenses incurred, which I mentioned, physical and psychiatric treatment, इसपे जो भी खर्चा होता है, for that the compensation has to be paid the agreed women by the respondent. Appeal can be filed against the order within 90 days to the appellate authority. There is prohibition for disclosing the contents of the inquiry or anything related to the complaint. It can't be divulged even under the RTI Act. There is a penalty of 5,000 for any disclosure. Duties of employer. This is important knowledge to understand. To provide safe working environment for women, constitute PIC, display legal consequences of sexual harassment, organize workshops regularly, facilitate IC and LC wherever they need help, assist in attendance of respondents and witnesses, provide information to IC and LC, assist women in filing complaints, initiate action against perpetrator, include sexual harassment and misconduct in your service rules, monitor timely submission of reports by IC. Duties are district officer. This I think we are not more concerned. Annual report has to be submitted. Penalties against employer for not constituting IC. If the IC is not constituted in any establishment, there is a penalty cost. For not taking any action on the report of the IC, for not taking action against person making false complaint. There may be person who is making a false complaint or giving a false documents. In that case also there is a penalty. For not sending annual report, fine rupees up to 50,000, and fine under the company law is from 50,000 to 2,50,000. Penalties for subsequent contravention is twice the original. False complaint I have already mentioned. Punishments I just discussed. Written apology, warning, demands, censure, withholding, promotion, increment, termination, counseling, community center. But in case the woman is not able to prove are constitutional provisions. सर मेरा टाइम हुआ या नहीं? I'm not really
सर
myself.
नहीं सर, आप बताएं ना सर।
Now there are some other aspects of it which I would like to mention, because act is not everything. There are certain things, social things also. At workplace, POSH के side, to the agreed human, this is loss of interest and motivation in job, loss of health and depression, loss of security and fear of losing job, loss of self-esteem, humiliation and discrimination. These are the consequences of acts of sexual harassment. To the respondent, what happens to you? Loss of reputation, loss of competent support staff, उसके साथ कोई काम नहीं करना था. Ultimately, loss of job. Organization को क्या नुकसान होता है? Loss of efficiency in production. This atmosphere is there. Then the people will start losing interest. They will start try to defend themselves. Maybe मुझे उससे दूर रहना है, मुझे उससे cooperate नहीं करना, मुझे उसके साथ काम नहीं करना है. So this loss of efficiency in production, loss of valuable staff. Some people may not work in that organization. Loss of image and reputation of the organization. Ultimately, loss of reasonable person, this is important. Every person takes other person's reaction, his comments, his gestures differently. For example, a typical, if somebody says good morning madam, something very good. But every 5 minutes, 10 minutes, he starts saying good morning, जब भी रास्ते में मिले good morning madam. This is annoying. So, personal perception is very important. How the women takes the advances, the words, the meaning behind the words. I think women is the best person to judge what kind of touch this is. So, perception may differ from different. If some lady has come in very nice dress, some is a very nice dress, looking very. They may be using any word where you look beautiful, beauty, good, beauty, looking sexy, looking for whatever. But this is the relation between the two, which allows to accept or not to accept. So the perception is different of different person with the other party. Individuals behave and expect on same thing differently with different persons. Rules by women employees. Be simply professional. Avoid personal intimacy. Do not ignore sexual harassment as trivial or mean. Monitor your own conduct. Make notes of incidents with date, time and location. कब किसने क्या कहा था? If you are going to make a complaint, discuss with our women employees how to handle this situation. Talk to right person, but this is a difficult question. Who is the right person? Talk to the boss. I don't know whether he will be favoring you or he will be thinking, okay, this lady is not sensible. Do not fall prey to promise of false rewards. If any wrong, unwelcome conduct advances in the part, शुरू में ही इसको no is no. Dare to confront, learn to say big no. This is very important. Don't always speak out and properly. Other than statutory provision, जो शुरू में हमने जल्दी discuss कर लिए, these are practically more important things. I consider कि जब वो प्रोग्राम होता है तो मैं इन चीजों को शुरू statutory provision तो आपने पढ़ी ही rules for the employees provide women friendly safe and clean work environment engage more women employees if there are more employees then the confidence level is different have fair and firm zero tolerance anti-sexual harassment policy install CCTV at crucial points let all dark spots in the office have transparent offices now the offices are changed previously you used to take now it is all glasses so it is also actually very good improvement display anti-sexual harassment policy include sexual harassment as serious misconduct in social resource arrange awareness workshop assist women employees in taking complaint some of them have practically what I have seen we were discussing outside also there are many establishments who have internal committees there are many establishments who don't have internal committees either they don't know or not aware but many of them they know it they don't want to do it they think if we discuss this among employees then the complaint will start coming in एक awareness जो है देखिए it will give a negative effect but that is not right law is law law prescribes to have committee you must have now this is also something important why this act comes कानून से लॉ से आज तक कोई क्राइम नहीं हुआ जितने कानून बने हैं उतने क्राइम बढ़ रहे हैं अगर कानून से क्राइम रुकते तो एक छोटे से किताब से ही सारे क्राइम रुक जाते हैं मोर लॉज यू हैव मोर वायलेशन देयर आर हम बचपन से एक चीज सुनते आ रहे हैं अगर कोई माहौल बहुत जगह अच्छा है ईमानदारी है चोरी चकारी कुछ नहीं है वहाँ कहते हैं पुलिस स्टेशन खोल चोरियाँ डकैतियाँ क्राइम तो सोशल एस्पेक्ट भी है इसके I give importance to this also. Used by the society, inculcate good values starting from home. Impart value education at school and colleges. Do not ignore regress conduct anywhere. What law cannot do, society can do. POSH crimes and leaders. Increasing women employees. This is also one of the reasons. पहले लोग घर में रहते थे, डोमेस्टिक फैमिली, होमली बेबीज होती थी, बाहर जाना नहीं होता था, इंटरेक्शन नहीं होता था, मेल एम्प्लॉय. Now they are more in number, they are out. Then there are chances of mingling with other genders. So this is also one thing. Opportunity and proximity. There is a lot of opportunity. Even in this hall, women, members are much more than very few lay persons. Managing social values. This is really very serious. Social values are really managed. पहले कोई गलत काम करते हुए भी करते हैं, सोचते नहीं थे कि ये गलत काम करना है. कोई I think there is no line between good and bad. Sanskars are becoming sanskar without sanskar. Value less education. हमारी education to have some values that education may be more suitable in this commercial atmosphere. Values not. In fact, this is very अगर मैं इसको कहने चाहूँ इस तरह से कि हमने वो टाइम देखा है कि जब दुकानों में घरों में भगवानों के तस्वीरें होती थी करेंट होते थे आजकल क्या करता है अभी जो देखता है वही सीखता है इवन न्यूज़पेपर्स some people may be calling it not newspaper a newspaper especially जो मैगजीन पोर्शन आपका जो अखबारों में आता है you can understand pseudo liberal हो गया प्रिंट मीडिया का, टीवी का, फिल्म मीडिया का बहुत बड़ा रोल है। हमने वो टाइम देखा है जब हम छोटे बच्चे के सामने कोई बड़ा बच्चा या कोई गलत बात करता था, हम कहते थे ऐसा मत करो, जो देखेगा वो गलत करेगा। आजकल ये शायद घर में हम सुनने को नहीं मिलते। फिल्म मीडिया इसके अंदर, टीवी मीडिया इसका बहुत बड़ा नेगेटिव रोल है। एक लेडी टीवी के ऊपर एक बार मैंने सुना था कि कोई कह रहा था कि हमारे बच्चे न्यूज़ चैनल देख के बिगड़ गए हैं। न्यूज़ चैनल क्या ऐसे ही दिखाते हैं। प्राइस ऑफ सूडो मैच्योरिटी इन डेवलपमेंट, वी आर पेइंग द प्राइस ऑफ inconsistency in three P's. Man is supposed to be protector, provider, but he is facilitator also. Patriarchy, इसके सबसे बड़ा इल्जाम लगता है कि सोसाइटी हमेशा से patriarchy है। There are three P's. Power, macho power is there. Position, women is the position, property. Very strong player. Man is supposed to be the protector. Man is supposed to be the creator. Man is supposed to do all these things. लेकिन उसके अंदर एक मेलहुड भी है, और ये मेलहुड सब में होती है, whether it is humans, whether it is animals, whether it is insects, whether it is birds, anything. There are two genders, male and female, लेकिन man सिर्फ humans में होता है। और what is manhood? Eat, sleep and procreate. लेकिन man में एक additional quality है कि वो एक creative है, constructive रोल है, फंक्शन है, समाज के अंदर फैमिली को पालना है। इस दुनिया का जो ये बनाया है, ये मैंने बनाया है, मेरे नहीं। Attraction towards opposite gender is natural. One thing is common in all animals, as I said. Eat, sleep and procreate. Procreation is because males are seed carriers. Sex by default is the basic instinct. Unfortunately, malehood is overtaking the man. This is the crux. Sexual harassment के पीछे भी manhood नहीं है, malehood. जो अच्छे लोग हैं वो manhood में आते हैं, जो गलत लोग हैं वो malehood में आते हैं, क्योंकि मेल का जो फंक्शन है, चाहे वो जानवर है या कोई भी है, eat, sleep and procreate, तो वो जो तीसरा जो पोर्शन है वो malehood, वो हावी है, जिसकी वजह से कि सेक्सुअल हरासमेंट के केसेस नजर आते हैं। But maybe this is my thinking, the origin of the problem, it is tribal, eternal. From day one, this has since Adam and Eve. उन्होंने जो भगवान की बात नहीं मानी, उसके बाद ये शुरू हुआ। I don't know what do you think of this thing. ये पिक्चर है ढाक का पत्ता होता है, एक मुहावरा है ढाक के तीन पत्ते, इस पे तीन पत्ते ही आते हैं हमेशा। तो ये जो मेलहुड है वो मेलहुड ही रहेगी। After all, man will be man. Understanding man will be man. मेरे पास कुछ ग्राफिक्स भी है जिससे कुछ I have tried to give the message on this subject. मुझे क्या नजर आ रहा है इसमें? But he is male. तो मेरे पास ये दो हैं छोटी चीज मैं इस पे सब्जेक्ट भी दिखा रहा हूँ कि आदमी से अगर कोई कुछ बात की जाए तो वो कहाँ पहुँचता है। जस्ट 1-2 मिनट लूँगा। साउंड है? काम कर रहा है वो लड़की उसकी सीक्रेट कर रही है। एक छोटा सा बड़ा अच्छा पॉजिटिव है। आई थिंक एवरीवन विल प्रेज दिस जेंटलमैन, जिसको कहते हैं भारत का ये सही भारत का था, लेकिन उसका जवाब देखिए। जवाब दिया, इसको लोग अपने अपने जवाब दिला सकते हैं। You want to hear it again or? Very good.
My name is Amelia. I work in digital communication. My question is very simple. What excites you the most?
That's the most difficult question I've ever asked. How will I say that publicly?
Thank you, sir.
Thank you very much.
Good afternoon, everyone. Thank you, sir, for such a lovely presentation, and thank you, Dr. Mitra, for having me here this afternoon. I just first want to ask everybody, is everybody comfortable with the English language, or would you rather that I speak in Hindi, because I'm adept at both? Or would you like a mix of both, because there's no point if I speak and not understood really well. So, Hindi, raise your hands. English, raise your hands. Both? Both, okay, lovely. So, we're discussing a very important topic here. One of the things that Sir said at the beginning of his presentation was, it is unfortunate that we have to have a legislation like the Prevention of Sexual Harassment Act. How many of you have actually heard about this act? How many of you actually know what this act is about, truly? So, the truth is, first of all, I personally, I'm a woman, but I personally have a problem that this is called the Prevention of Sexual Harassment of Women. Because A, let's remember, this act has been made by the Parliament of India for protection of women. So I'm so sorry for the men in the room. No protection for you guys. Because obviously nobody expects you to be harassed. Everybody expects that you will be the person who's harassing. I do a lot of trainings in sexual harassment for a lot of companies, both don't get harassed. Okay, so I want to cover that because I know very few people cover that. But to keep myself on the real specific topic of the legislation itself, which has been made for the protection of women, like I showed a lot of these videos and a lot of the mentality and a lot of the thought process that men will be men, etc. That's the precise reason why we have this act in place in the first place, I think. I don't subscribe to the view that people will be this way only and that's okay. It's not okay. But I also feel that because there is an act in place, people should really do something about it and there should be more awareness about it. Every company has the legal requirement to ensure that they're actually passing on that message and ensuring that people in the company know what this act is for. They have an internal complaints committee. How many of you in your organization have an ICC? How many of you are aware that you have an ICC? Obviously those who raise their hands will raise them again. How many of you know how the ICC works? See, there you go. So you may have had the ICC since 2016 or since whenever this act is in place. Very few people, however, know how it works. How many of you have seen posters in your organization in different places telling you about the Sexual Harassment Act? How many have you seen posters which tell you about how an ICC is supposed to function? Right? So, what's the point of having an act, having it in your organization as a policy document, and then not knowing what to do about it? It's as good as not having it, right? Because your people don't know how to use it. So, what's the point? We can come into trainings, we can hear about it, we can go back, and let me tell you, there is a mandate, and so please correct me if I'm wrong, under the Act which requires that companies have to A, have an ICC, B, they have to disseminate their information and have posters around their organization or share within the organization that they actually have this. This is a legal requirement, by the way. One of the things also that he said, which is very interesting, is a lot of times we don't want to talk about it because we feel प्रॉब्लम क्यों क्रिएट कर रहे हो? नहीं पता है लोगों को तो मत बताओ. जो बोलोगे जितना बताओगे फिर उसका मिसयूज होगा, लोग उसके बारे में कंप्लेन करेंगे. तो हमारा क्लासिक कल्चरल कॉन्सेप्ट है put it under the carpet. Don't talk about it. Don't raise it. And this is something which I will connect to the societal aspect. Even at home, when it comes to our children or our sisters or our mothers or our whoever, any women in the house, इसके बारे में बात मत करो. Because if you talk about it, it's a problem. But when a wife comes to her husband and talks about it, or a daughter comes to her father and talks about it, we have a very different approach, do we? How many men in this room will be okay if, for example, I have a daughter, by the way. How many men in this room will be okay if their daughter was being harassed? Will they take any steps or not take any steps? Will you take steps? Let's raise our hands to those who will take steps. Let's raise our hands to those who will take very serious steps. Right? So I guess all men will take very seriously. But when it comes to the workplace, it becomes very easy for us to say, problematic hai, lady hi pagal hai. Right? How many times have you heard lady hi pagal hai? How many times have you heard single hai na, to bilkul frustrated hai. Right? This is also a classic case of sexual harassment. One of the topics that does not get covered a lot of times is sexually colored remarks. किसी को कोई idea what is sexually colored remarks? This is banned, it's prohibited. The Act says you can't use a sexually colored remark. What is a sexually colored remark? Before I ask you that, how many of you genuinely feel embarrassed when the word sexual is used? Raise your hands when anybody feels embarrassed. Please don't be embarrassed about raising your hands. Come on. Right? Now, that's the principal problem. That is where the problem starts. Because we have a problem about the word itself. हम वर्ड ही नहीं बोल पा रहे हैं तो हम उस टॉपिक को डिस्कस क्या करेंगे, क्या समझेगा कोई भी. My request to everybody, and I do this in every training, for my sake, at the count of 3, all of us together will say sexual. Okay? 1, 2, 3. Sexual. Louder. 1, 2, 3. Sexual. Not too difficult, right? It's easy. So long as you consider it as something which is not ho, because there is nothing ho about it. The moment it is, you will never find a solution to it. If you want to find a solution, first get over the taboo. That's one of the things that he said about society, about changing perception, about changing thought processes. What will the law do when you yourself are not comfortable talking about an issue? The law can do nothing. But when the law is there and you actually implement it properly, and I have personally sat on and I continue to sit on ICCs of several companies. I have done many investigations. I can give you many live examples, but I'll wait till we have the interactive session when we have that to give you those examples of how this actually happens. I have seen many companies where the policies are gender agnostic. Although the law says it should only be for women, there are companies that have policies that apply both to men and women both. Do all of you have a sexual harassment policy in your organization?
Yes.
Are all of them for women only?
Yes.
Is there anybody here who has a policy which is for men and women both?
My ex-organization has that policy.
Yeah, okay, that's nice. That's good to know. Because that's the future, by the way, that's going to happen. It will happen soon. So I was talking about sexually colored remarks. Anybody know any example you can give me of sexually colored remarks? You're looking very hot. Is that a sexually colored remark? Yeah? Okay. She's really fat. Is that a sexually colored remark? Yes? Somebody says no, okay, body shaming. I'm very happy somebody said that. Body shaming. So she has very beautiful eyes. Is that a sexually colored remark? No. Good. I'm so happy. See, you don't need training. You know it all. So, okay, it's for example, if you say she has nice eyes. Yeah. How do you know the difference between when you say nice eyes, then it's sexually colored, but when you say nice eyes, it's not sexually colored? How do you know the difference? I'll give you an example. When we go to someone's house, okay, like you're invited by a relative of yours. Some chacha ji has called you for some dinner at his house. उन्होंने फोन किया बोला अच्छा हमारे डिनर में आ जाना. अब उनके साथ आपका थोड़ा रिश्ता अच्छा पक्का सा है, पर उनको फॉर्मेलिटी में बुलाना था, उन्होंने बुला लिया आपको, आप पहुंच गए. अब आप उनके घर गए, your wife, children, everybody. You went there, you had dinner, you sat down, you spoke to people, you came back, and घर आके you said अच्छा नहीं लगा. गए, तो आपकी वाइफ बोलती है क्यों इतने अच्छे से उन्होंने बुलाया, खाना भी खिलाया, गिफ्ट भी दिया, क्या अच्छा नहीं लगा? तो आप बोलते हो नहीं, पर you know want me, समझ मतलब कुछ हाँ मिसिंग था कुछ. सबके साथ हुआ है कभी ना कभी, हमें कैसे पता लगता है कुछ मिसिंग था? क्या फीलिंग होती है वो अंदर? वाइब्स होती है, वो एक फीलिंग होती है, राइट? सो सेक्सुअल हैरेसमेंट एक्ट में एक चीज का ध्यान आप हमेशा रखिए, it is the impact that you have on a person. It is not your intent. मैंने ये सोचा नहीं था, पर मेरा ये इंटेंट नहीं था, पर मैं आपको ढूंढ रहा था, पर मैं आपको बुरी तरह नहीं देख रहा था, मैं तो कुछ और सोच रहा था. आपकी शक्ल ना फलाने से मिलती है, कोई भी बहाना, like any, you know, like people have those really stupid pickup lines also. That have I seen you somewhere before? Like come on, that's so daft, it's so dumb, it's very old. Try something new, you know. But the second thing is that women have, and I'm sorry, but I'm going to say this. Women don't ever nip it in the bud, like he said. They have this tendency of, you know, हमें लगता है कि अरे गलती से बोल दिया होगा यार, अरे छोड़ो ना यार, why become a problem? अरे जाने दो ना यार, it's all right. This is the very start of the problem. You know, जब तक आप खड़े होके पहले बोल नहीं देते ना, मतलब please don't talk to me like that, it's not okay. क्या प्रॉब्लम है किसी को बोलने में? I am not okay you speaking to me like this. अच्छा नहीं लगा मुझे. Exactly what we just said ना, vibe अच्छा नहीं लगा. Vibe आई है ना गलत, तो गलत ही होगा. अगर गलत ही है ना, तो please speak up. Because speaking up is the start and the end of this problem. लॉ हम जितना मर्जी बता दें आपको कि हाँ जी सेक्सुअल हैरेसमेंट है, आप कंप्लेन कर सकते हो, 7 दिन में वो उसको बोलेंगे, 10 दिन में वो रिप्लाई करेगा, 20 दिन बाद हम इन्वेस्टिगेशन करेंगे, 3 महीने में इन्वेस्टिगेशन पूरी करेंगे, फिर हम उसको कुछ रिकमेंडेशन दे देंगे. The other thing is false complaints, and I really want to spend just 1 minute on that. A lot of times I have also seen personally in the investigations that I do that people misuse this law. Alright, there are women who misuse this law by making false complaints also. Are any of you aware of any false complaints you may have heard? Yeah, this can destroy careers. It can finish up a family. So one has to be very careful when you are using this law. हमारे डाउरी हैरेसमेंट में 498A करके लॉ हुआ करता था कुछ साल पहले का. I don't know if any of you know about it. जिसमें अगर कोई लड़की डाउरी हैरेसमेंट का केस करती है तो उसके हस्बैंड, फादर इन लॉ, मदर इन लॉ सबको पहले अरेस्ट करके जेल में डाल देते थे, राइट? क्योंकि तब ब्राइड बर्निंग ये सब बहुत ज़्यादा रैम्पेंट था. It became such a big menace that we had to come up with a law like 498 to arrest people. Today that law does not exist. Why? Because people started misusing this law. So my request to people is don't misuse this law because it doesn't take anything. It can be taken away. You start realizing that there's misuse. क्या ये take away तो नहीं होगा. Just provisions और stringent हो जाएंगे. So those are some of the thoughts I had, and there are a lot more, but I want to respect the time allowance that has been given to me. I think I will take on questions and make this interactive after Mr. Mohammed has had a chance to speak. So over to you. I hope I'm not encroached on your time. Please, sir.
Thank you, Ms. Priyanka. In fact, both Mr. Saini and Ms. Priyanka have made my job easy. I am actually a practitioner in industry. He is a eminent in education. He teaches, he practices in court, the highest apex court. So they have had their vision on their own area. Now I am actually in industry where we practice the things. And I represent, as Mr. Mitra has already said, I represent Engineers India Limited, which is a Navaratna company and a Ministry of Petroleum. So when we train our people, when we tell the nature story, we always try to give a little brief story in the beginning, how it originated. Because we have heard about enactment from Mr. Sani. We have heard about some live cases with how people will understand it is sexually colored or how we will understand the perception, etc. You must be knowing with about 2 sentences I tell. The origin of this came from 1992. It was Dhanwari Devi's case in Rajasthan, who was a Dalit woman when there was no enactment, no law, and she was working in Rajasthan government in a government department, and she was brutally raped, and there was no enactment of law. And that was the time in 1992. It is so late. You see, India got independence in 47. It was in 92 when the incidents happened, and then again another 5 years it took time when a NGO first Visakha, you have heard about Visakha guidelines, how it came. It is from that. Another NGO Visakha came to Supreme Court with this fighting about the case of Ms. Dhanwari Devi of 1992. And then finally Supreme Court made a guidelines. Again it is guidelines. That is called Visakha guidelines. It was from 97, certain guidelines came. And then finally Government of India thought some enactment is required to be made. Because we being in PSUs, and generally whatever we do, we are actually a model employer. Even maternity leave, when it was not 6 months by enactment, we had 6 months in our own policy. So generally the benevolency in PSUs are already there. It may have a bad effect that people may say all benefits they take, but we do those benevolency. So 2013 enactment was made, what Mr. Saini was giving some points. I think it becomes mandatory for every company, whether it is PSUs, whether it is private sector, you have to have certain bylaws followed in your company, which one of the is internal sexual harassment committee, prevention of sexual harassment. It is must. I hope most of the company here, I think, is private sector company. I think they have all as of now. I think everybody has this internal sexual committee. I hope. Any company which does not have, if they do not have, it is basically you are violating the enactment of that 2013. Now, few things as a industry practitioner, I will mention to you which you know. The enactment you will not have time. I know any practitioner who will not have much time. She is a lawyer, she will know everything. He is teaching student, he will know everything. But for a person who is working, including my company, few of my colleagues are there, it's not possible for them to go every clauses of enactment. So, few things one should remember as a person who is working, that's getting from an industry. You should have that in the enactment section 2, which is basically the section 2 is basically the act defines the sexual harassment. I am only saying few things you should know. You need not go through the entire act. You should know what is sexual harassment, it is section 2. What is workplace? There is a definition of workplace. People may get confused. What is workplace? It will include everything. I am just telling it could be companies, it could be nursing home, it could be farms, it could be hospitals, it could be sports facilities, it could be NGOs, it could be houses, it could be companies, it could be service provider, it could be corporate societies. These are all workplaces. So all people are not in a unified area. They think I am in a company, I am in a farm, so this is workplace. What I said is these are all workplaces. Who is the employer? Again, employer could be workplace, government, it could be government, it could be private, it could be dwelling house, it could be head of officer specified, it could be person, it could be domestic, who is employing a domestic helper. Then third definition one should know, it is only I am telling you who are basically working anywhere, whether it is private or public. Who is aggrieved domain? There is a definition who is aggrieved domain. Working, visiting workplace, student, domestic worker, regular, temporary, ad hoc workers, for remuneration, voluntary basis, employing directly through an agent, contract worker, contract labor, whatever, all are basically aggrieved domain. Anybody. So these are the few definitions one should keep in mind. I am covered under all these parameters. So this is one. If you do not read the act, even when it is enough, you should have this in mind. Then coming to being in public sector, we are under certain umbrella. Other than enactment is obviously has to be followed in any companies. But in PSUs also, we are under umbrella of DPE, Department of Public Enterprise Guidelines. There are the guidelines issued in 2014 on maternity leave. There was guidelines issued in 2017, which is very important, which is basically model conduct rules. And these model conduct rules basically, actually even if it is issued by DPE, it is basically for everyone. Like in private organization also, when you do not have your standing order conduct rules, you follow model standing orders. So it is like that. Government introduced a model standing, it is like a model conduct rules in 2017, where they are specified few things that your conduct rules. I think most of the company must have your own conduct rules. If not, I think you are no more following the standing order, model standing orders. So you have your own conduct rules. You must have incorporated certain provisions in your conduct rules. You must have that provisions in your conduct rules. What are the elements of provisions in the Act of 2013? You must have that to be defined as a misconduct. So few things which model conduct rules has defined in 2017, which I hope all PSUs have incorporated. All PSUs must, they are required to be incorporated. I hope private sector has incorporated. Like in Engineers India, we have our conduct rules incorporated immediately. Employees shall strictly refrain from sexual harassment of any female employee, endeavor to prevent and deter commission of acts of sexual harassment in the workplace. We have another clause, provide that an employee shall, as soon as incidents of sexual harassment comes to his or her knowledge. Again, I am saying his because she mentioned that is it gender rate. So, like all steps necessary and reasonable to assist the affected person in terms of support and preventive action and report the matter to the official superior. And it is defined under misconduct, under which, like any of misconduct, this is also under that means you have minor misconduct, you have major misconduct defined on the basis of your amount of harassment rate. Then we have internal sexual committee, we have NGOs outside, we have an executive director heading that committee, and after every 2 years that committee is revived, and any type of incidents happening in the company, it is immediately brought to that internal sexual harassment committee, and then within 390 days it is tried to be resolved. As of now, we have no cases that it has reached to the appellate authority, that is, they were not satisfied with the report of the committee. Now, what are the other elements one practicing company should do? They should endeavor a safe working environment at the workplace, including safety of the person. We also do the workshop and awareness program regular intervals for the employees to understand the provisions of the Act. The penal consequences of the sexual harassment and the order constituting the internal committee are displayed in the conspicuous place in the EI premises. EI treats sexual harassment as a misconduct under the service rules and initiates actions for such misconduct and monitor timely submission. Now, once you incorporate such clause in your misconduct, 50% of your problem is solved. Because people will understand. The company, even I am also suggesting the private company which have not incorporated this clause in their misconduct, please do it immediately. Because that fear psychosis must be there in the employee, because once they know, ठीक है वो तो है इंटरनल सेक्सुअल कमिटी, बट हमारा कॉन्टैक्ट रूल्स पे तो है नहीं, पता नहीं हो क्या मेरा व्हाट पेनल्टी विल बी given to me. But once you know it is there in the misconduct, it is defined in the misconduct, and it could be major misconduct, there is minor misconduct, it could be major misconduct, then why I say 50%, then automatically that fear feelings will be there in the employee before they go ahead with anything of such matter, they will think twice, because once this is there in your misconduct. So please do follow. And if you do not have, please go back to your company, tell the company, because this is one as per requirement or even in the year also, as per the parameter, it must have. And in case of the PSUs, there are other enactment also. That is, if you are listed company, it has to be reported to SEBI. It is produced in the annual report, etc., which are regularly done in our case. Last 2 years we do not have such any cases. Now again I said, by 50% of the cases are solved. See, once it was constituted in the conduct rules, there were some few cases in our company which was there in the reports, and there were, I take that point of perception. I can remember a practical point. Some female employee complained about that. Initially there were some WhatsApp messages, good morning, good evening, then it went on continuously that message, and she could understand that message is not a welcome message. Every time good morning, good evening. So then she came back to the committee. Now it was first 2-3 years there used to be a complaint, but last 2 years there was no complaint, because everybody is now aware there is a committee, it is there in the conduct rules. So I request all the companies to have such stringent thing in your place, then you will see this type of incidents have, if not zero, it will become minimal to your place. So with this, I have just shared the experience of what we are practicing in our company, in English India Limited. We like to have your question on the question session and answer session.
Thank you so much. So, we'd like to read for question answer session. But before that, I'd like to touch upon as a hard-nosed practicing manager. Issue is very rightly pointed out by my pastor, Mr. Saini, that in a civilized society like ours, what made us create a specific law for compliance. He has also gone to the extent of saying that when the animal is seen, that works, that can happen, that is gender neutral, then you need to have some corrective remedial measures. Issue is, if you look at our constitution, Indian constitution, Article 21 talks about that personal dignity and liberty. So, outraging of modesty, be it women, be it any person, is violative of Article 21. Okay, Vishaka judgment, the background, the genesis, whom we talked about. In fact, post that 1997 judgment, it took 16 years for the legislators to come up with a piece of legislation. But before that, something had also happened. There was an amendment to Indian Penal Code, because it's a criminal offense. When you think about criminal offense, there are two laws. One is substantive law, we call it Indian Penal Code, and then we call CRPC, the Criminal Procedure Code. So section 354A was brought in. Anyway, this is the first part of the genesis. The second part, everybody talks about the Internal Complaints Committee, now it is known as IC, Internal Committee. It is highly empowered committee. Whenever we look at any misconduct, we find that in an organization we hold departmental inquiry. Please mind it. The inquiry officer or the inquiry authority, they do not enjoy power to make any recommendation about the imposition of the penalty. Please mind it. The inquiring authority or the inquiring officer is only expected to give their findings, whether the charges or the allegations are found okay or not, whether they are guilty of that allegations or not, but they do not have any power to make any recommendation. IC is totally empowered, be it interim recommendations, be it final recommendation. So, anybody, any aggrieved person, when he goes to the IC, and when IC makes a recommendation that he should be transferred immediately, or he should be given additional leave, or post the the investigation, they make a recommendation he should be removed from the service. The disciplinary authority does not enjoy that liberty to overrule the recommendation generally, because the IC is totally empowered to make recommendations. That you must distinguish. Now, what Mr. Bhomik said, that as per the guidelines and as per the issued by the DP, so two things are essentially required for any PSU to follow. One, that they should make an amendment to their conduct, discipline and appeal rules. One, that the sexual harassment is a part of in the list of the misconducts. Secondly, once the law is evolving, there could be decisions are at variance at various courts of law in the very high court. In some places it says the IC recommendation post investigation will have to get validated through a departmental inquiry as well. And therefore, it is imperative that your civil rules should speak about that no further inquiry is required. Once IC has undertaken the investigation, that should be treated as a final investigation. We have gone for amendment to that effect. Due to the paucity of time, I am not making mention of all those Supreme Court judgments. Because, and third, lastly, what Madam said, yes, I have authored one POSH policy for one of the IIMs, and Madam, I have tried to make it gender neutral. Because it is being misused at times by the women workforce. Let's not get into there anymore. So we are left with another 4-5 minutes time. So by 4 o'clock we should break for 10-15 minutes and then we'll have the valedictory session. So please, panel is available before you. Kindly ask your questions.
Ma'am, I have a question. Once the ICC committee receives the complaint, what should be the step-by-step things to be taken forward?
So, I think I certainly have a slide on that, I remember. And so the way it works is, once a complaint is received by the ICC, within 7 days, a copy of them, first there's an option of conciliation. So you meet the person and you see if they want to settle a matter. Settlement does not, however, mean they don't forget about it. Settlement means that, sometimes issues are very small and they don't really require a full-blown investigation. It could be something as, not as invasive, but it could be something like, somebody looks at me in a very not so nice fashion. So you can actually make the people sit down and say that, look, there is certain decorum you follow. So there's conciliation that you have. Monetary compensation cannot be made the basis of that conciliation. If, however, the person says, no, there is no settlement, I want you to go ahead and investigate this matter, then within 7 days you have to give a copy of that complaint to the respondent and the person against whom the complaint is there. And that person is given 10 days to provide his response. Now, within 10 days thereafter, the lady can be asked to give a rejoinder or her response. Both parties are also at liberty to provide witnesses or people that they feel should be spoken to in support of their case. Overall, the ICC has about 90 days to complete this investigation. When they're doing the investigation, they work really like a court of law. So you can summon witnesses, you can ask for evidence, you can talk to different people, whoever you feel is relevant in order to actually do a proper, thorough investigation. So there are simple things that we call that you follow principles of natural justice. Each person is given a right or an opportunity to speak about it, present their case. Then the ICC sits together, deliberates, each person gives their view on the entire matter, and within 90 days you're supposed to come out with you're basically supposed to complete the investigation. And then 10 days thereafter you have to give your findings on what you feel has happened in the matter and what your findings are. Have I covered it correctly? That's how it works.
Findings will be shared with both the...
Yes, findings have to be shared with both the parties and also with the management of the company who is then supposed to take action as deemed necessary. No, I don't think so, because if you try to cross-question between the complainant and the respondent, it will never be. Of course. They don't cross-question the witnesses. The ICC goes ahead and talks to different people. Once we know what the witness has said, we can go back and tell the person that, look, this is what we have found. But ideally, normally, we try and avoid giving any names, because what happens is then you compromise the confidentiality of the whole process. And confidentiality is really important in this particular aspect. At least I lay a lot of emphasis on it. Because if the entire company knows about what's going on, then you really defeat the purpose of what you're trying to do. So that.
Madam, in fact, examination in chief, it happened in the course of, in case there is star witness, who is the witness to the incident or event, in such situation there could be a process. Otherwise, Madam rightly pointed out, there is no economy. So one-to-one affair, there is no question of process.
Basically, in industry, what we do is 90 days is the basic target. We always try to see that it is completed. We generally do that. And the committee separately talks to the accused as well as the person who is complaining. It is in the rarest of the rare case, we ask both the person to sit together. ऐसे situation शायद एक बार हुआ था in our company, where both were giving a contradictory statement that just now as Mr. Mitra said, sometimes somebody takes benefit of that. So you wanted to be sure of that, whether something false allegation was being made or not. But again, it was for a one single chance it happened, otherwise generally committee sits separately with both.
And these findings, when it is shared with the both parties, they can give a their counter.
No. So you have the option of seeking their views when you are doing the investigation. The final findings, once they are given, if a person is aggrieved by those, they can file an appeal. There is a provision for an appeal under the Industrial Standing Orders Act. Right?
Yes.
So you have the option of filing an appeal, but you don't have, otherwise it will become never ending. You will never be able to finish the investigation.
So once the finding is submitted, then the disciplinary authority.
Then the matter is over as far as the ICC is concerned.
No basis of finding is also given along.
This is a division of opinion on that. I feel that that should be given because then you show the whole process of honest, proper appreciation. There are people who feel that you don't have to, but I think the Act says you have to give your findings along with reasons.
Ma'am, they are on
Has to be a reasoned order ultimately.
They are on-roll employees, and then we have interns, summer trainees, contractual.
They are all covered.
They are all covered.
They are all covered. That is the whole concept of the extended workspace also.
Yes.
Visitors also.
With the findings, the IC will give the recommendation also. Punishment.
We do, yes. We do give the recommendation.
That's why I said in the initial section 2, please see the definition.
Yeah.
Everybody is covered. All gamut of person is covered.
On the basis of finding include witness statements.
We can say that we obviously tell them that we've discussed, we've spoken to people, and they know who the witnesses are because they're the ones who've given us the witnesses. But you don't say who said what and what was specifically said by who, because otherwise it will become a big, absolute ruckus. In particular, in order to solve one problem, you would have created 10 more problems.
The penalty क्या होगा? Who will decide? Disciplinary authority or ICC?
See, it's a mix of both, but I will invite my co-panelists also to reply to that. In my experience, I have seen that the ICC does give recommendations, but it's ultimately the management's decision, frankly. So you have to let the management also decide. But I asked your, yeah.
In industry, you have rightly asked, we have a disciplinary authority. The committee gives a recommendation about the misconduct has taken place. There is a of history. Then it is put up to the disciplinary authority. The disciplinary authority in all PSUs, I hope it is there in the private sector as well. Disciplinary authority is mentioned. Suppose for GM, who is the disciplinary authority, suppose for ED, who is the junior officer, who is the disciplinary authority. So DA decides what is the punishment. The A is based on the recommendation of the internal committee. And it is very, that's why I said, I repeatedly said, I am again repeatedly saying, the conduct rules defines very clearly what is the graveness of that accusation.
In fact, I will add to this, what sir said very important. Service rules, any service rules of an organization must always provide this. What is the disciplinary action that can be taken? Now, in different cases, there are different types of actions. So, for example, the highest is termination of services. Then there is a financial penalty. The financial penalty could be that your promotion is stopped, your increment is stopped, or you're actually asked to pay X amount of money because a person has suffered so much or so much gravely. Or there is a reprimand that is given, or there's a warning that's given, or there is some other form of. Now, ideally, this should be, like I said, I totally agree with him, they should be part of your service rules because tomorrow otherwise, somebody can challenge it and say that, on what basis have you given me this? You know, who are you to give me this?
The last
So-
question, sir.
Yeah.
I want to ask, is there any definition of women with the contribution in respect of age? What is the minimum age after which a girl can be called as a woman? To whom this act will be given?
No,
Means
there is
that
no-
10 years girl can be covered under this act?
Yeah.
Instead of any age.
Yes, any age means
Any age. But normally what happens is when you have cases like that, you want a POSH, potential child abuse type of things. But, like for example, people have domestic workers in their house, sometimes they're 11 years old, but they're covered.
in office also there is a great facility nowadays in there are kinds of the
Yeah.
employee. If something will happen to them also then
No, but then they're not employees,
But
right?
it is
And
already
agreed to
employed or
employee.
not. And unless it is employed or not, if a woman of any age is employed or not, they will
That's
be
right, they can be covered, but to make it simpler for you, for example, if we, in the example you have given, if there is a child who's coming to a crash every day, it'll actually be covered by POSH if I'm wrong. If I'm
Yes,
right.
yes, you are correct.
Because it can't be, you can't read another sexual harassment act, because then how will you show quid pro quo,
But
sexual
the
favor?
age is, this line is 15 up to 10 years. Is there any age which is possible?
No. Oh, also, of course, there is child-friendly statute.
Up to this age?
I
No,
know
sir,
it's
sir, we
16.
can do that.
Up till
The
16
thing
years.
is that the three categories. One is child labor, one is adolescent labor, जो young worker बोला जाता है, third is adult worker.
उसको देना
तो 14 साल के नीचे जो होते हैं, उसको चाइल्ड लेबर बोलते हैं। उसके लिए मैंने
40 साल के बाद से बोल रहे हो
हाँ?
Under 18 I was.
young worker है, up to 18, तो up to 18 जो adult worker नहीं होता है, वो POSH पे cover है। Anyway, friend, like एक ही पॉइंट है, प्लीज डोंट गो अवे, क्योंकि इसके बाद में हमने बहुत ही इंटरेस्टिंग सेशन पेंडिंग है, वो वैलिडिटी सेशन